RIA introduced a lot of changes, a lot of investor-friendly changes. Now, it's debatable if they've been implemented, but Anu, again, starting with you, could you shed light on visa set-asides for under different categories and priority processing?
Sure. So the RIA that was passed last year created something called set-asides. That means that 32% of the visas that are allocated to EB-5 every year, which is 10,000 in total, are supposed to be put aside for people that are investing in specific projects. So 20% of visas are supposed to go to people that invest in something called a rural project. 10% is supposed to go for people who invest in projects where they are in a high unemployment area, and 2% is supposed to go to people who are in infrastructure projects. And those set-asides are kept for 2 years. And then after 2 years, if they're not used up, they're released to the rest of the categories. The major boon was for Chinese nationals, and then for Vietnamese national, and for Indian nationals. And the reason why it was such a boon for them is because each of those 3 categories did have a visa cutoff date established, meaning that at some point, if your green card or your 526 petition was approved, you may not have been immediately eligible to file for a green card. You had to wait until that priority date became current. And what the creation of the set-asides did was it created subcategories within EB-5 that were now all of a sudden current. And I think someone else will probably cover it later on, but that combined with concurrent filing meant that Chinese nationals, Indian nationals, and Vietnamese nationals who happened to be present in the United States were all of a sudden eligible to file for their green card along with their 526 petition, which for people from other countries, definitely that was a change and great for them to be able to apply for a green card as well. But for people from China, India, Vietnam, it was not expected that they would have been able to do so or do so quickly. So that really has helped the market. The other thing was over the last few months now, with all of the tech layoffs, EB-5 has become such an opportunity for people to remain in the US. So yes, USCIS threw a bone at us and said, you have 60 days to find a new position if you're H-1B, if you're terminated on your H-1B, and you can file a subsequent H-1B petition. What we found is a lot of people were tired of kind of being stuck with their employer and reliant on their employer. So they turned to EB-5. And again, because of the set-asides, India was current or is current, and they're able to file for a green card, which allows them to stay in the United States and also file for work authorization and travel permit. So those set-asides were really helpful to those people from those 3 countries, and very specifically to people who are in the United States and who got laid off and were able to use this as a way to remain in the United States. And so set-asides are current, and I believe at the last stakeholders meeting, USCIS had indicated that it is expected to remain current for at least 1 more fiscal year, but it is definitely helpful for everyone who's in the United States to file for that green card. Abhi, you had a second question. What was that?
That was, I just wanted to know, wanted you to shed light on priority processing.
So priority processing is the government initially claimed that they were doing something called first in, first out, meaning that the first person who filed the petition would get adjudicated prior to the people who filed their petitions after that person. So again, simple, first in, you're going to be the first one adjudicated. But now there's something called priority processing, which is kind of 2-part. The first is going to be that people who are in this set-asides are going to get priority processing, meaning that their 526 petitions are supposed to be adjudicated faster. Plus, people whose priority dates are current are supposed to get adjudicated faster. So if you know your country is in a backlog, let's say prior to 2021, you filed and you're from China, you're stuck in a backlog, your case is not expected to be processed faster than those who are filing now who may have a current priority date. Now, realistically and practically, this is the US government. I am not sure they're going to be as efficient as we would like them to be. And we still now see processing that doesn't fully make sense. So people who filed subsequently are getting approved first, even if they're backlogged and the prior applicants are current. But that is the game plan, is that the people who are current are supposed to get priority processing. People in those set-asides are supposed to get the priority processing for the 526 petition only.
Thanks, Anu. Nima, it'll be great if you could just share the nuts and bolts of adjustment of status and how it has helped investors within the United States over the last 1 year.
Yeah, absolutely. So, as I said earlier, EB-1, EB-2, EB-3 always have the benefit of concurrent filing. It is now extended to EB-5 as a result of the RIA. I think when people hear concurrent filing, they think that the green card must be filed when you file the EB-5. Concurrent filing just means you can file the green card anytime before the EB-5 is approved. After the EB-5 is approved, then it's just an adjustment of status. It's available to anybody that is in the United States in a valid visa. Valid visa is carrying a lot of work there. Because what is a valid visa for adjustment of status? Well, anyone that's certainly in the US in an H1 or an L1, which is a dual intent visa, they can pursue the green card immediately. They can continue to live, work, and travel on the H and L while the adjustment of status is pending. Someone that is a student that has been in the United States post 90 days, or maybe has been in the United States even since before COVID, has the opportunity to pursue the adjustment of status. As soon as that adjustment of status is filed, they now have an additional status in the United States of pending green card. Everyone filing the adjustment of status gets the benefit of the EAD work authorization, as well as the advanced parole travel visa. The big difference for someone that's here in an H or an L, which is a dual intent, or a tourist visa, or an F1, or a TN, or an E2, any of these non-immigrant visas, is that once you file the adjustment of status and have the status of pending green card, you actually can't leave the United States until you get that advanced parole application. The visa that you entered with, the non-immigrant visa, is no longer going to be valid. So that could, with current processing times, the advanced parole is somewhere between 6 and 8 months. So for someone entering the United States with the idea that they want to adjust, they could be looking at a 9-month or 1-year period that you're inside the United States. So really a huge boost for anybody in the United States.
Thanks, Nima.